Such a pleasure to be joining you right here on the India Development Debate on ET Now. I'm Supriya Shrinate, and tonight we're putting the spotlight on an issue of utmost importance, on an issue that may actually impact you, the viewer, as much as it impacts each one of us here in the studios. The deck speakers have been cleared for India to somehow become a surveillance state, with central government ready to take up the role of a big brother, it seems. In a controversial decision, the Modi Sarkaar has given a carte blanche to its investigative spy and tax agencies to snoop upon its citizens. The order allows agencies like CBI, IB, ED, RAW, military intelligence to intercept, monitor and decrypt any information stored, transmitted or generated through computer resources. The decisions of the Ministry of Home Affairs published through Government Gazette has put the spotlight back on the debate between privacy on one hand and interference by the state on the other. The pronouncement comes almost 1.5 years later, by being told of the Supreme Court that privacy is a fundamental right. The opposition believes that government was unleashed the biggest surveillance program since independence, which would have disastrous consequences. The Union Cabinet, and none other than the Finance Minister, has justified the move, citing security concerns and the advent of technology. He's tried to allay fears that snooping would only be done after being authorized by the Home Secretary. Though the law was actually enacted in 2009 under UPA, it was never implemented as agencies were not specified. The repercussions of government's order and what it means for an individual's privacy is a big topic of discussion right here on the India Development Debate this evening. I've got Vineet Goenka, member and ex-national co-convener of the IT cell. He was also a member of the task force of IT1 that did look into this, and which is why it's important to have him here. I've also got Rohan Gupta, spokesperson of the Congress, Pranesh Prakash, affiliated fellow Yale Information Society Project, Neha Chaudhary, public policy lead, TRA Law. Thanks very much, each one of you, for being with us. And, you know, before I go any further, Pranesh, to you then, the Home Ministry's order authorizes 10 central agencies to intercept, monitor and decrypt any information generated, transmitted, received or stored in any computer resource across the country. To make it simple, all computers in this country are under government watch. Are we officially a police state?
I would say that we have officially been a police state since 2009, from when the IT Act amendments came into force and these rules indeed were passed. Now, it also suggests, just to be clear for the audience, the power to order interception is separate from the notification today. The power to order interception is with the Home Secretary at the MHA or the Home Secretaries at the state level. Now, all states and the central government have this power, and these agencies operate under their orders. So, for any instance, for putting someone or a class of persons or for some topic under interception, they need specific authorization, specific order from the government, from the Home Secretary, and they can't proceed without that. So this notification doesn't actually add new powers. Those powers were added in 2009 itself, and those we at the Center for Internet and Society submitted was actually unconstitutional because it was overbroad. It didn't do enough to protect privacy. The kinds of punishment provided under that under the Act was excessive, and so
right
on and so forth. So the real problem lies not with this notification, not with this order, but with the parent rules and the Act.
No, I will tell you where I'm going to take this debate right now, Pranesh. Give me a minute, and I'm going to take this across to politicians. And to politicians, my first question, Vineet Goenka, has to be, and Pranesh, just to clarify what you've said here, you're right. This provision existed on the Gazette since 2009, and any citizen should have had an issue with this. The difference is that what was an enabling provision, the provision which very clearly says the competent authority may authorize an agency, is today an order that says the competent authority hereby authorizes the following security and intelligence agencies. So the provision that was there for these authorities to be authorized have now been done. And that is the big difference between 2009 and 2018. For everybody who's watching this show, the big difference between 2009 and 2018 is that the 2009 order makes a provision for this surveillance, But the 2018 order makes it a reality. And let me quote the two court orders really. The first 2009 order says, competent authority may authorize an agency of the government to intercept, monitor or decrypt information generated, transmitted, received or stored in any computer resource for the purpose specified in subsection 1 of the section 69 of the IT Act. Fair point indeed. 2018 order reads, the competent authority hereby authorizes the following security and intelligence agencies for the purpose. Mr. Vineet Goenka, the reality is that what was an enabling provision, and that is where the political crossfire is really happening. The Congress said you're becoming a snooping state. The BJP retorted by saying this is being done in the name of security, and it was actually done by you. Right, it was done by them. It was a provision then. You are making it a reality by implementing that provision, and that's the difference.
Supriya ji, we will have to go back to 1885 when the Telegraph Act was done. There was in provision in Telegraph Act where the state can actually monitor if it is required. And there were certain authorizations there. Then in 2008, we faced a very severe attack, that was Mumbai 2611 attack. And thereafter, NSA report of 2008 talked about 800 terrorist cells and the need of these kind of provisions. Let me remind you, 2008 NSA report said that. And in 2009, October 27th, this provision was made under the CCTNS approach. Now, once it was done, it was very, very vague. I would like to rather congratulate the current dispensation, the government in power, that they have clarified who are the agencies who can monitor it. Now, if you see, there is a clarity. Who will monitor it? Now, the CISF will not monitor you. This X agency, Y agency will not monitor it. This is the 10 agencies which will monitor you. And who they will monitor? They will monitor people who are anti-national, who from where there is a threat to the nation. You and I and the citizens or the corporates need not worry about this. And as far as it goes, there was surveillance or monitoring being done on these anti-national elements, irrespective of whatever provisions were there in IT Act, whether it was CRPC or so, there was done. I think probably we have to see this order in a light that it was a necessity of 2008 attack. Then you see, CMS 2011, it was provision was there. So all these provisions were there, and surprisingly, today, when they have clarified who 10 agencies will do it, I don't know why people are making noise.
What was a provision is today a reality. Today somebody can decide that my computer needs to be intercepted and that can be done. Till today, one second, till today, no, one second, I know the provisions are there. Till today, there was only a provision that an authority may be authorized to do so. Today, the authority has been authorized, and that is the question. But I'll go to Neha before I come back to Pranesh. And Neha, how much will the citizens of this country have to grin and bear the whole thing about security? I understand our security is paramount. There are no two ways about it. First it was Aadhaar, then it was demonetization, now it's this. I mean, how much do we have to grin and bear in the name of security as common citizens? There is this lurking suspicion that my computer or your computer could actually be up for interception.
Yeah, thanks. So I think I'm just going to agree with what Pranesh said. The fundamental problem, more than just the order that has come out today, is the underlying provision that enables the government to come out with such an order to begin with, right? And in this case, we are talking about Section 69(1) specifically of the IT Act. And I'm absolutely with you when you say that security of the state is important, and it absolutely is. But at the same time, we do also have to look at the implications that this has for all of our fundamental right to privacy, which the Supreme Court recognized in the Puttaswamy judgment as being a fundamental right. And if you look at the report that the Justice Sri Krishna Committee released a while ago, there is in fact some conversation that they do have around this specific provision, Section 69(1) of the IT Act, where they do say that in light of the Puttaswamy judgment, having laid down that restrictions on a citizen's on our fundamental right to privacy need to fulfill a three-part test, which is that these restrictions must be pursuant to a legitimate state aim, must be backed by law, and must meet the standards of necessary and proportional, right? So, and the report in fact then goes on to say that in light of the Puttaswamy judgment, this provision of Section 69(1) is potentially unconstitutional, right? So, you're absolutely right when you say that we have to vet security of the state on the one hand, but there are serious implications for privacy of you and I. And this is something that has been recognized as well. So yeah.
No, 1 second. Rohan Gupta, why are you not on camera? I have an issue with that. You should have been on camera by now. The show was supposed to start at 6. But just to be the devil's advocate, I have to raise a point with you. Does the government not have a point when it says that the order has been executed given the advent of technology and the instances of radicalization by ISIS even in parts of India? I mean, I am presuming here, and I'm right in my assumption, that terrorist or antisocial elements are no longer restricting or using their activities to phones and SMSs or calls. They have access to the best of technology, to computer, and this will perhaps help in a meaningful crackdown. That's the argument that the government is giving on this, and some part of that one may not be hesitant to agree with.
See, I agree with your point when you started. See, basically the problem is not with the provision. The problem is with the blanket permission. What this government has done, they have given blanket permission to agents to snoop into anyone's computer. See, this is totally against the fundamental right of privacy. If it is a national issue or it's an issue concerning national security, government still has the power. These agencies still have that special power. But when you are giving blanket approval, it means that you are opening it to the misuse of power by these agencies. I think that's not done. You have any issue, security issue or any issue concerning national security, all these agencies are empowered enough to take steps. But blanket permission is something I think it is totally going against the right of privacy for this country. And I think this is not the first attempt this government has done. I was on debate in your channel only regarding this social media hub. Then the government scrapped that idea. But I think if you see the intent of this government, every now and then they have tried that somehow they want to snoop into the right of privacy of these citizens.
Okay. The reality, Rohan Gupta, also is, and I kind of agree with Pranesh, it may have been an enabling provision in 2009. It has only been implemented now. Why did you put it as a provision? The fact that 69, subsection 1 of 69 of the IT Act, why should a provision like this be there? That is my fundamental issue today.
See,
why did you put it there? And I think you have to answer that question as well. I'll come back to you and I'll come back to you. Give me a minute. It was never blanket and today it's blanket. That's all right. I'm coming back to you. Give me a minute, Vineet Goenka. I want to go to Pranesh. And Pranesh, according to the order, the subscriber or the service provider or any person in charge of the computer resource will be bound to extend all facilities and technical assistance to the agencies, failing which he or she invites a 7-year imprisonment and a fine. Now, how is this going to be decided upon about who is going to be pried? In the Telegraph Act, for instance, there are provisions under which this should be done. The same provisions apply here, but it's never transparent. And it's never transparent because if you actually see the kind of people who were being intercepted by the Telegraph Act, were not people who were a threat to national security or to India's defense or to the security of the state and our sovereignty. So how does one decide who has to be pried upon?
So a few things. One, everyone keeps talking about national security, national security. This provision as passed by the UPA in 2009 is not restricted just to national security. The law is in the public domain. I urge the opposition and the government to please read it before talking about national security and how this will be used only for that. It actually says even investigation of crimes which are not related to national security can be done under this provision. Okay, and interception and monitoring and decryption can be done even for interception of crimes which have nothing to do with national security. Okay, so please get that out of the way. Secondly, there's a big problem caused by this order being passed today, which is from 2009 till 2018, the government seems to be suggesting that there was no interception done whatsoever, which we know is not true. Interception has been done under Section 69, and indeed in response to RTI requests, they have mentioned that the review committee has sat down in review of such interception and so on, and this is in regard to RTIs that the Center for Internet and Society submitted way back in 2010 or 11 or so. And so we know that this has been operational, but it's been operational without saying which agencies actually may receive this information. So it's been operational in a unlawful manner. So that for me is the real problem. This notification should have come out in 2009, enabling certain agencies to receive information on the basis of interception monitoring and to engage in it. But instead of doing that, for 9 years, we've had unlawful surveillance under Section 69 of the IT Act, which is a problem. Okay, so just to be clear, the power for interception should exist. It should be narrow. It should be in line with the Supreme Court judgment in 2016. But this is not such a provision. This is not narrow. This is not proportional. And this also shows that there has been unlawful interception since 2009.
Oh, yes, there has been, and there is no denying that, because before I go across to Vineet Goenka, there are 5 provisions under which the Telegraph Act or this can be invoked. And let me read out the provisions for the benefit of our viewers here. In the interest of the sovereignty and integrity of India, for defense of India, for security of the state, for friendly relations with foreign states or public order, or for preventing incitement to the commission of any cognizable offense relating to any of these above. Obviously, nobody should have an issue with that. Explain to me now, and this is really the question, you know, yes, an investigation of any offense. Fair point indeed. Neha, you know, before I go across to Vineet Goenka, the question is that all of these 5 conditions are good enough conditions for anybody to intercept. There is no denying that. But how do you explain that the Telegraph Act or the phone tapping of Neera Radia, was she a national sovereign threat? How do you explain the cricket bookies? Were they a national or social threat? How do you explain Amar Singh's case being tapped? I mean, all of this obviously was being done by the tax department, and there is this larger clamor that why should the tax department be authorized to tap anything? Forget about, you know, it should not have done under the Telegraph Act. It should definitely not be a provision on this. Look at how grossly misused that provision is. Neha.
Right. Right. So, I mean, this leads us to a conversation on what kind of oversight mechanisms and checks and balances that you do have for the government's exercise of this power under Section 69, right? Whether it's under the IT Act or similar provisions that come through under the Telegraph Act and the Post Office Act. Here in particular, the oversight mechanism comes through, again, Pranesh was alluding to this a little bit. You have a review committee and the order for interception, etc., goes through the Home Secretary. But there is no kind of either judicial or legislative oversight, right? So what you ideally want is when the executive branch here is exercising its powers, you do want there to be some kind of mechanism where there is oversight by one of the other 2 branches of the government. Again, this has come through in the Justice Sri Krishna report that I was talking about earlier, right? They themselves have spoken about other countries having in place similar oversight mechanisms, whether it is legislative or whether it is judicial, right? So what you ideally want is when such a warrant for interception or monitoring is issued by any executive agency or by the executive agency that the law decides is the authority to issue this warrant, you want that warrant to be reviewed by a judicial authority to see whether or not there was application of mind.
Yeah, I'm going to cut you short there.
It meets the standards of necessity and proportionality, you know, and things like that. Yeah.
Okay, Neha, I'm going to cut you short there. I want to go across to Vineet Goenka. And Vineet Goenka, just for the benefit of our viewers, and the reason why we have you on this show is because you obviously understand this a lot better than some of your other party colleagues do. Unlike a phone call that is being tapped, in computer interception, data collection doesn't start with the time of interception. If I am an authority that's tapping a phone call, I can get CDR backdated, but I can tap the content of the call from the time I begin interception. In this, I can go back many, many years. I have access to somebody's mail. What stops me from checking mails from 2010 to 2006 and all of that? I mean, isn't that unfettered access an issue as well?
So let me give you 3 parts to it. One, let me tell you, it is not spooking. It is intervention and interception.
Yes, names, so people say this is snooping.
Yeah, so let me just put it is not to be worried, and this citizens, corporates, regular persons should not worry about this. This is done very systematically by all the governments since the Telegraph Act has come in. Now, as the technology progresses, those days telegraphs were there, letters were there, so they had that kind of provisions. Now there are emails and other data mobilization technology, so probably the things have to be changed. So it's a migration and a progression of the law. Yeah. But where does it come from? It comes from the 2008 MHA proposed creation of NIG. So it is not 2018, it was 2008, and I do not blame that government 2008 because it was necessary under the National Security Act. Now here the interception can be done on any data providing technology. And it is good. If you see who are the agencies are Narcotic Control Bureau. Why would Narcotic Control Bureau investigate as regular citizen? It will do to somebody whom they are fearing that he is a drug peddler, who is a Enforcement Directorate, where they fear that he is an economical offender. If you see NIA, Cabinet Secretariat, now all these people are very responsible people. Till now, there was no authorization. So yes, if you say that, till now whatever was done, probably was done on a discretionary power of the Home Secretary. Today there is an authorization. Rather, we should be happy as a country that we have done it. If you see the debate of privacy versus national security, many times take a call, but I will recall to you the privacy bill which has been come in place, the provisions which are there in debate. The data protection, personal data protection bill which has been debated right now, and maybe someday it will come back. Yeah. Probably will provide a protection to the normal citizen. So normal citizen need not be worried about this. And Sri Krishna
right.
Tenants which are there, all the 7 tenants are very strong. Rather, I was debating and I have written to Honorable Justice Sri Krishna on a personal note. That
Goenka, I understand that maybe you are well intentioned. The reality is when you give a power like this to people, it is not always going to be used for the right reasons. There are 5 right reasons why they should be invoked. None of those right reasons meet the, meet the muster as far as Neera Radia or the cricket bookies in Srisant case or Amar Singh are concerned. So there is misuse, and this will be misused. I'm not going to be happy with the fact that somebody can look to my phone, forget about the phone directly. Somebody can now look into my computer and see the mails that I was sending in 2010. This is not on. But give me.
Currently also it is happening, but it is happening without authorization.
So what is legal is not right. That's all that I'm saying. What is legal is what is, it's not.
So that's it. Now it is legal to do it. So people will not take advantage of this.
I want to go across to Sanjay Jha. And Sanjay, a clarification has now come in, which was not there earlier. And it says just like the Telegraph Act, the Home Secretary will have to authorize an interception like this, and the Cabinet Secretary is going to review it just like he does on a monthly basis. Is that ring fencing it enough?
Supriya, I'll tell you what we need to be concerned about, and I'm talking more as a citizen of the country and not just as a political representative of my party. The point is, if you look at over the last 4.5 years, anybody who's critical of this government, anybody who takes on Prime Minister Modi, or anybody who makes up on sensitive cross-border issues that the government doesn't think is appropriate is branded an anti-national, and they are called as a threat to national security. Give you a perfect example. Kanhaiya Kumar in JNU, for whatever he said, was called by Home Minister Rajnath Singh as a terrorist belonging to the Hafez group. This is coming from the Home Minister of this country. Now, going by the laws that they are talking about, any one of us is vulnerable based on the perceptions of the government to be called an anti-national, and therefore they could come to our homes, seize our smartphones and our computers, and look up anything they want, from pictures, from postcards, from any kind of video you have, your entire history of emails, chats, archived chats, what have you. I mean, to that extent, I think we are very near to a police state. Because much as the BJP can try and say that this was part of the law framed in 2008, they need to look at that very carefully. That you can't implement stuff on national security or anything that is anti-state unless you read the Supreme Court verdict. Now, during the time, you have had the Supreme Court verdict on the right to privacy, on which you and I both know that the government went to the courts saying that we don't believe that the right to privacy is a fundamental right. And that tells you the overall attitude of this government towards individual freedom. Now, if you couple the two, don't decouple it, couple the two, you realize we do become extremely vulnerable. The way this can be executed by the 10 agencies, I can tell you, this can frighten business, this can frighten India Inc., this can frighten, anybody who's an opponent of the government. NGOs, everyone.
Yes.
Yes.
So what is legal is not right. That's all that I'm saying. What is legal is what is. Give me a minute.
Absolutely.
Sanjay. Right. No, no, anybody, absolutely. I mean, look at what's happening with Amnesty International and all those NGOs. So one is tempted to believe, you know, there is reason to be concerned. But Pranesh, I want to come back to you, and you know, the reality is that if you read this with what the Supreme Court has said, and the Supreme Court has very categorically said that privacy is a fundamental right. I know it was opposed in court by the government of the day, and which is why perhaps, you know, one is suspicious of the intent right now. You know, what is the chance of this meeting the scrutiny of law? Because once the Supreme Court has said this privacy is a fundamental right. So that's one question. And what about the vagueness of the term any information? I'm presuming that then covers anything from our Facebook profiles to our WhatsApp messages to what we tweet, because everything is on computer and any information can amount to just about anything.
I must point out that to access your emails from 2006, actually they don't even need to go under section 69. They just need to go under the CRPC, and so under which the standards are even lower. So the standards are somewhat higher for interception, monitoring, and decryption. But even then, even under the law as it stood in 2009, we argued that it was unconstitutional for a variety of reasons. Under the Telegraph Act, there are only those 5 grounds that you mentioned. Under the IT Act, they add a 6th ground and they remove the conditions which are only for emergency and for threat to public safety, which are there in the Telegraph Act. So the IT Act is like a watered down, much more expanded version of the Telegraph Act, and the Telegraph Act is a colonial legislation passed by the British government, and they gave Indian colonial subjects greater rights than the Indian government right now is granting its citizens, which I find gravely ironical. Secondly, a number of other constitutional provisions, including Article 14, Article 21, Article 20, Clause 3, are violated by this. If the opposition and the UPA is actually serious about this, then they will call for an amendment to the IT Act to actually bring it in line with the Constitution, and they won't just point out this order. So unless they actually call for an amendment to the IT Act and to the rules, I find this as only paying lip service to privacy just because they're now in the opposition. If they're serious about it, the actual act must be amended, and we must, for instance, the Intelligence Bureau and the R&AW, right now they don't fall under any legislature. They're not answerable to Parliament. They're not answerable to ordinary citizens. So how can they have powers to indulge in interception when they're not absolutely above parliamentary and legislative scrutiny? So if the opposition is serious, they must call for extensive reform of intelligence gathering in India to actually put in place privacy protection and to amend the IT Act and other laws which actually grant overbroad powers to the government.
Okay, just give me a minute, Pranesh, because I think you're absolutely right. Your stand can't be where you're sitting in Parliament, and I think that's the problem right now with the Congress. Why did you put that enabling provision to begin with? Is it time that everybody removes it? But give me a minute now. I'll go across to Vineet Goenka. And Mr. Goenka, there are 10 authorized agencies for interception right now, monitoring and decryption and whatever else. IB, the Narcotics Bureau, ED, CBDT, DRAI, CBI, NIA, RAW, and quite interestingly, the Director of Signal Intelligence and the Commissioner of Police of Delhi, of course. The reality is that there were a lot of agencies that were authorized earlier also under the Telegraph Act, but military was never brought in. For the first time, we are seeing the army being brought into surveillance. In some sense, are they sidestepping agencies like RAW and NTRO and and IB? Why do you need these agencies if army is also going to do pretty much the same thing that these investigative agencies or surveillance agencies do?
I'm sure your viewers all know the roles of different agencies which they are doing. Narcotics department does a different role, RAW has a different role altogether, and the signals which is operating in JNK Northeast and specifically in the Assam, these are FASP areas, and probably these areas have a different kind of situation, and when you have different kind of situation, you need different kind of agencies to work there. So authorizing them is a right move which the government has done, otherwise they would depend on the inputs coming from other agencies, and that may delay. If you just go to Jammu and Kashmir, you may say there are situations which have to be handled within seconds of erupting. Now you have seen many situations there in JNK and also in Assam, and I think probably the move is appropriate which has been authorizing to them. And if you see in the case of Commissioner of Police, because all the national territories, everywhere, wherever you go, national capital territories of almost all the countries have these kind of provisions, and this provision has been appropriately done. Let me bring your attention back to one more fact. See, till now there was a vague thing, anybody can be authorized. Now they have defined it, and I rather probably believe that this is in the spirit of Supreme Court's advice to narrow it, and this narrowing to 10 agency makes me very comfortable as a citizen. Rather, I would like to ask a question to Sanjay Jaji, who talked about all the big words. If this was true, then how did Neera Waradia tape came out where, Ratan Tata was talking to him? How did, Amar Singh's tape came out? And also let me remind to the viewers here, Rajiv Gandhi pulled out his support to Chandrasekhar's government on Snooping case. There were two constables standing out. So, so the toothless tiger of our agencies today have got tooth. So as a citizen, I am very happy. Rather, I would like to ask one question to the government. 2018 का क्यों इंतजार किया? पहले क्यों नहीं किया? 2009 में क्यों नहीं किया? Because I have not done anything. I don't have any fear. I have never done activity. So in case I am being surveyed for a minute, assume that somebody tries to check my data, I have no problem because I have never evaded tax. I have never done any of that.
But that's my point. We need Goenka.
The problem is the people who are challenging the integrity of the country, and I welcome this
listen to me.
And I rather question to the lawmakers.
You have to listen to me now. I agree with you. I have never evaded a tax. I think I've overpaid taxes for 3 years in a row and I haven't even taken my refund. So first things first. I have not evaded taxes. I am not an anti-social element. I don't get involved with anything that's, any anti-India. I am as nationalist as they come. I'm as patriotic, and nobody has the right to question my patriotism. Where I disagree with you is, why should there be a remote chance of my computer being intercepted? That's the simple logic, the simple question that I'm trying to raise through this show. I'm not just putting you in the dock. I'm also, excuse me, trying to put the Congress in the dock for putting that provision. What you've really done is you've gone a step further, you've executed it. Give me a minute, I'll go across to Neha, then to Pranesh, and then of course you very quickly. Neha, what are the chances that this is going to meet the scrutiny of law? How likely is this to be struck down? Because the Supreme Court has categorically said privacy is a fundamental right.
Right, so I mean, we'll have to examine not just, more than the order, you'll need to examine the parent legislation, right? And that's what it'll come down to. To me, it'll come down to whether or not that parent legislation is in furtherance of the Supreme Court judgment and whether or not it's necessary and proportionate. And arguably it isn't, right? Because the grounds on which you can intercept, monitor or decrypt are fairly wide, and I think they do go beyond the 5 or 6 grounds that the Supreme Court itself identifies in the Puttaswamy judgment. So I do think that there is a reasonably strong case to be made out for reviewing the constitutionality of this section and maybe narrowing its scope and having in place some kind of additional oversight mechanisms. So if we did have judicial oversight or if we had legislative oversight and if we narrowed the grounds on which narrowed the grounds that are there present in section 69(1), that could probably bring it more in line with what the Supreme Court was talking about in the right to privacy judgment.
Okay. Two last questions, and we're going to cut to you first. The reason I think the intention is being questioned is because of the stance that the government has taken in court at various times and the actions that it has done. On the right to privacy, the government took a completely contrarian stance in the court saying it is not a fundamental right. It then tried to bring in the social communication hub bill. Obviously, that raised much ire, wasn't a reality. And my own presumption is these are the actions of the past that is making the intention questionable. Are you going to at least be frank and candid and concede that even though the motive may be different here, but actions of the past are making people question the decision now?
No, I partially agree with you. In 1975, the way emergency was imposed and, the right of individuals were harmed. So, probably the intention of all the politicians have been questioned. But if you see the technological advancement and what is happening in the West, the geopolitics is changed. Now it has become a technopolitics. So, you will have to understand this. If the threat is there to the country, the nation state has a right to put in things in place. And this is fairly a transparent process. There is a clarity, of course, here. And I would also say the checks and balances are there. This is not a raw balance. Rather, 2008 provision was raw. There was no definitions been given. Now there is a definition been given, and I would like to congratulate the people who done it. My only question to them is, why did they take 9 years? They should have done that in 2009. Why did they put the entire country's national security at risk? So probably that question both the governments have to do, the earlier government and the current government, that why did they take 9 days? I will also like to bring your attention to CCTNS, the Crime Criminal Tracking Network System, which was put in 2009. Now there, if you see, as low as 14,000 police stations were connected. Now, police station handle what? They handle murders, they may handle rape, they may also handle pickpockets, and the pickpockets data was collected under that. So now, if you see, if they were trying to collect data of pickpocketers, this is fairly necessary.
Pickpockets are perhaps not as prevalent as some of the sleeping cells in India are, and that security is paramount. I also did not miss the point that when I asked you on the government stance, you went on to 1975, 2017 or 18 ka Supreme Court stance aapko yaad nahi raha. But I understand your political affiliation, and I know why you did that. Pranesh, I'll give the last word to you, and the last word has to be that while this debate is going to be overshadowed by politics of the day, while politicians will continue to take pot shots at each other, there is a dire need to balance the need for privacy on one hand and the security of the country on the other. Terrorists today have access to absolutely top-notch, high-end technology. It is not as if you can nab, sleeping cells by just tracking telephones. Stuff is happening on the internet. Stuff is happening on the, computers. How do you balance the two seemingly parallel, non-meeting issues? Privacy on one hand and the security of this country on the other.
A former colleague of mine, Sunil Abraham, says that surveillance is like salt. It's absolutely necessary for a nation state, but if you have too much of it, it starts harming you. So absolutely we need provisions in the law to enable interception, to enable surveillance. However, those provisions must be in line with our fundamental rights. This isn't in doubt. What people like Vineet Goenka kept saying is that we need provisions for national security. I completely agree. I believe that the provisions that are there right now don't go far beyond national security and actually harm our privacy, since they go far beyond national security, since the penalties under it are higher even than the penalties under the Official Secrets Act. Okay, so and I despise the fact that every time there's a question about fundamental rights, politicians and legislatures, MPs and MLAs, whose job it is to pass laws and to amend laws so that they are in line with fundamental rights, keep saying, let the court decide. Why should the court decide on whether fundamental rights are being violated? Aren't MPs erudite in law? Don't they understand fundamental rights, which they're supposed to? Why don't they ask for the law to be amended? So for me, that's the simple question that we should all be asking. Why did the government in the past pass such a law? Why is the current government, which was then in opposition, why didn't it question it then? Why now are they continuing something even though it goes far beyond national security? And when will we finally have security agencies being answerable to Parliament and to the people? And again, let's remember, we're talking only about the central government, but all these powers are right now exercisable by all state governments, and at the state government level, there's far, far less scrutiny. They haven't even passed this kind of
absolutely.
Order.
No, absolutely, Pranesh.
Which agencies can engage in this?
No, absolutely. One is tempted to agree with you there that the scrutiny and the level of, scrutiny is extremely low even as the states are concerned. But thank you very much on that note. I'm completely out of time here. I borrowed time from my next show actually, but completely out of time here. Thank you very much, Pranesh, Neha, Vineet Goenka, and of course Rohan Gupta and Sanjay Jha, both from the Congress, who joined us. The lines kept dropping. But thank you very much for being with us in this edition of Media Development. Now, even as we take a quick breather, it is important to remind our people here that the big state is watching you. The government can legally now intercept your computers and access any information there. This is being done because there was a provision in the IT Act Section 69 which authorizes the government to do so. This authority was put into the Act by a law that was passed in 2009. The difference between 2009 and 2018 is that in 2009, right after 26/11 in Mumbai, this was an enabling provision that was put in, and that provision very categorically said that this may authorize the agencies. What has happened as of last night by the order of the Ministry of Home Affairs is the fact that this may authorize has now become hereby authorized. It has become a reality. There is always going to be this ensuing debate between rights of privacy that the Supreme Court has upheld as a fundamental right and, of course, the security of this country. There should be no two ways about meeting India's sovereignty, integrity, our defense, our relations with other foreign countries, investigation and all of that. The reality is that very often these provisions have been abused and misused for political purposes. And that is what citizens of this country to be wary of. Take a quick breather. There's plenty more that's happening right here in ET Now. Stay with us.